Can a sexual abuse survivor's behavior be called into question in a New Jersey civil case? And if so, can it reduce the amount of damages that they are awarded or potentially preclude them from making a recovery? My name's attorney Ben Andreozzi. My law firm, Andreozzi and Foote, is one of the nation's leading law firms representing survivors of sexual abuse in civil cases. I'm licensed to practice in New Jersey, and a question we've been asked by our New Jersey clients is whether the defendants can bring into question their behavior or conduct, and if so, can it be used to reduce the recovery they make or potentially dismiss their case? New Jersey has adopted what's called modified comparative negligence. If a plaintiff under modified comparative negligence is deemed to be 51% or greater at fault, that plaintiff is precluded from making a recovery. On the other hand, if the plaintiff's allocated fault or responsibility is deemed to be 50% or less, that amount of fault will be used to proportionately diminish the amount of the recovery. So for example, if a plaintiff makes a $100 recovery, but they are allocated or assigned 50% of the fault, the amount of damages they'd be able to recover in that case would be reduced to $50. Fortunately, in New Jersey, victim blaming is discouraged, and it's excluded in cases involving intentional torts or battery cases that are brought against the perpetrator in so much that the victim's conduct can't be called into question. The same is true in cases involving childhood victims of sexual assault who obviously can't consent to sexual conduct, and therefore their behavior can't be called into question. However, things are a little more murky in negligence cases and cases brought against organizations. We were able to find one line of cases that states defendants can't point the finger at victims looking at their alleged misconduct or their behavior if they had a duty to prevent that type of conduct or behavior. The example case was a hospital that tried to blame a mental health patient for self-harm. The issue of victim blaming, comparative negligence, and assigning fault to the plaintiff is a very complicated issue in New Jersey. So if you have questions related to this, please feel free to reach out and email us at info@vca.law, or for more information, visit our website, www.victimscivilattorneys.com.